platform right now. So with that said, can we go back to the Christed being, right? Because you're another ungrateful slave child who comes here for what daddy has. You come here for what daddy has, and you get up on daddy's platform and stage, but then you tell daddy, I don't need you and any of your people. So we know the kind of person you are, a taker, right? You're not a servant, you're not a giver, you're a taker and a lowlife.
Because you do such great work in your community. That's why you need YouTube to share.
With me in my life, with what I'm responsible for. I don't have to rely on other folks, like you said, to validate my walk and not. I do such great work, quote unquote, according to other people, with me, myself, and I on my channel.
All right, I'm down. So I'm not even mad at your fundraising.
You just did a drug deal, didn't you? You just did a drug deal and acted like we didn't hear that.
What?
Maybe.
Maybe.
Hey guys.
So there you go. That's what you're all about, right?
We're starting
doing drug deals
we're starting
in the
at 100.
Getting high, sitting
had me in
around
the
watching
backstage
me,
for a while.
criticizing
I'm trying
me,
to see
and
if
then
he's going to
helping
actually
me
let me come
to
up.
get some more fiat paper,
I think this might be a
so
bit
I
fun.
can go buy some paper towels to wipe my ass with and shit out here in a hole on the land. That's what you're into.
Yeah, I'm totally down with some sleazy fundraising. I'm not even against it.
Okay. So tell me more about the Christed being comment. How I'm bad and wrong because I have equated myself to a Christed being when my understanding of Christed just means conscious and aware of certain dynamics of creation. Tell me more about that.
So I really think that it's quite obvious that you're glossing over the fact that you're
this Lucifer
engaging
guy
in commerce.
I think he's another soft sit, but he's been calling out Paul for like the last 20 minutes.
I never said I didn't want anything to do with that system. You have to make your claims right. So I don't know where you got this information. You must be inferring some things.
I
said that when I'm doing commerce, I'm doing commerce. When I'm moving property in a private capacity, it's two different worlds. Doesn't mean I don't cross over into worlds from time to time. It means that
not doing commerce right now.
No, because I'm not using the roadway transporting property or people for profit. Are you that low level in consciousness? You can't see the difference. Me sitting in a car while it's stopped and not even running, having a conversation on a phone, and people donating me money from me using the roadway like a bus driver, a taxi driver, or a tractor trailer driver. You can't see the difference in those two concepts, huh?
Yeah, I can. I mean, I see the difference as being you're using the internet to sell your brand.
He's still going after him.
And what is my brand exactly?
Your brand is, I guess, this idea that you're a Christed being, and if people follow you and support you, they will be enlightened.
So you, even though you're a follower and a supporter with your most precious resource, well, you follow my broadcast and you're right here on time, and here you are talking to me, needing my attention.
I'm doing it for my benefit. This is for my benefit.
Oh.
I'm just gonna let this go in the background just in case he comes back up. I'll be able to tell. But let's go to actually why we're here. If you guys don't know, this is an evidentiary hearing involving the OnlyFans model Courtney Clenney, who is charged with second-degree murder of her boyfriend. This one actually kind of made some of the some bits of news not too long ago, mainly because she was not initially charged. She was kind of let go until people like made a stink about it, and then finally they finally issued a warrant and finally put her under arrest. She was arrested in Las Vegas and extradited, and this is an evidentiary hearing involving that case. Let me get this showing for you guys. And then close this crap out. There we go. So the issue that they're raising is the defense is trying to get a protective order on a lot of bits of evidence that came from the defendant's phone, her computer, etc. Mainly involving saying that there's a lot of explicit stuff that's on there that's not relevant to the case, and the concern is the potential prejudice against his client. Both the Miami Herald and the state's attorney's office are actually going to be speaking to this as well, in opposition to the protective order.
You got an 85.
Yeah.
No, that's an amended.
That may or may not be the defendant's parents. I'm not sure.
Yeah. For us, we slowed way down. Thank you so much.
We're about 1 minute early. Both sides ready to begin?
The state is ready.
All right, thank
Good
you.
morning.
We're on the record. All right, good morning, everyone. We're here on the matter.
I couldn't tell you, Jassa. You'd have to, I'd have to look at Florida's statute and how they define first and second degree murder.
Khalil Quinnan on behalf of the state of Florida.
Good morning, Your Honor. Frank Prieto on behalf of Ms. Clenney.
And Sabrina Puglisi on behalf of Ms. Clenney, who is present before the court.
Good morning. Good morning, ma'am.
Good morning, Your Honor. Scott Ponce on behalf of the Miami Herald. Only granted the legal interview.
Yes. Thank you. All right, this matter is set for today on the defense's motion for entry of a protective order and request for injunctive relief. Both sides ready to proceed?
State is ready.
Yes, Judge, defense is ready.
Just a few questions before I hear arguments of counsel. The matter is set for evidentiary hearing. At the last setting, I had inquired whether or not there was going to be any amendments or any supplemental filings. The court is under the understanding that there have not been any updated nor revised pleadings. Is that right?
Judge, no, that's incorrect. On August 29th, the defense filed an omnibus reply to both Miami Herald and the state. I do have a courtesy copy for the court.
Right.
Well, here's a
Was
color
that
copy.
e-filed? Was that sent to the
It was e-filed.
Okay. And from the state?
Nothing from the state, Judge.
All right. And Mr. Ponce?
Nothing from us, Your Honor.
All right, so there has not been an amended declaration filed as of yet?
No, ma'am.
Okay. All right, thank you. What was that?
From the judge?
Nothing from us, Your Honor.
All right, so
We who labor here seek only the truth. That's a good quote. I wonder where it's
there has
from.
not been an
Your Honor?
Just 1 second, Mr. Prieto, I take a look at your reply.
Yeah, I was going to offer the color copy. It is a little bit easier to read
Okay,
when you get
thank
towards
you.
the affidavit.
Sure.
Sure. It's the same. It's got the stamp on it.
All right, let's take a 5-minute recess. I'd like an opportunity to review your reply.
I appreciate that, Judge. And next time, I will make sure that Your Honor gets a copy with a binder with the relevant.
So the defense submitted a reply to the state's opposition, and the judge is getting a recess to go review it.
Office, where the victim's family was present, where the victim's attorney was present, attorney's office, in order to provide.
Prieto, it's the defense's burden. You may begin.
Yes, Judge, just to put this kind of in context, we're here on the defense's motion for protective order because of the influence that media can have on the fair and impartial administration of justice in this courtroom. In order to provide for the fair and impartial administration of justice for Ms. Clenney in this matter, we're requesting that Your Honor issue a protective order limiting the amount of discovery that would become subject to Chapter 119. We believe that the State Attorney's Office, beginning the day after Ms. Clenney's arrest, mobilized the media and utilized them as a tool. It's clear that the family of the decedent in this case also did the same. At a news conference the day after Ms. Clenney's arrest, put forth by the state attorney's office, where the victim's family was present, where the victim's attorney was present, and was given access to the state attorney's news conference at the end after Ms. Rundle was done speaking. The most poignant part about that state attorney news conference was the release of an elevator video that depicted a physical altercation between Ms. Clenney and Mr. Ombimselli. In that video, which has been disseminated by millions now and edited, it's not, the state attorney put it out there without any context. The beginning of that video shows Ms. Clenney trying to keep Mr. Ombimselli from getting onto the elevator. It's important to note that that elevator also goes directly to that apartment. But why is that important?
So he's talking about the infamous elevator video. Let me see if I can bring that up right quick. This one.
Stunningly apparent when it leads to a tragic direct of two at 3131 charging me murder building. You could now, if you look at either screen, you will now see the video.
Thank you, Thea, for being a 12-month member.
That's them entering their apartment.
The understanding is that it took several days before charges were filed.
The drip.
And I believe, it's my understanding that that footage was captured the day of the murder.
Drip and drip of release of video in this case, or audio, pictures, pornography, is going to erode our client's right.
Well, it is an OnlyFans.
Fair and impartial trial down the road, guaranteed by the Sixth Amendment and the Florida Constitution. Now that Rule 2.420 of the Rules of the Judicial Administration talk about the power that the court has, as outlined in my reply, and subject obviously to the Lewis test. We have to show that there's no other alternative other than seeking some type of closure, and in this case, a partial closure. The defense submits that we have met the burden by using the attached affidavit, which we submit to the court's evidence in this matter, and that is the affidavit of Michael Hans. But I'd like to go back. Before becoming a public record, well, let me back up. It's clear. Once the state turns over discovery to the defense, it becomes subject to Chapter 119, which has...
Thanks, Akira, for the $4.99 super chat.
Protecting the interests of third parties. In some cases, the defendant's confessions are protected. So these things would be redacted, and we'd like to hear from the state how they would plan to redact those items. But as a threshold matter, under the Rules of Judicial Administration, Your Honor has the power and the discretion, as indicated by the appellate courts. It's in the sound discretion of the trial judge to grant or limit criminal discovery. And that's State v. Kuntzman 643 SO2D 1172, and that's a third DCA case out of 1994. The Rules of Judicial Administration allow Your Honor to issue protective orders for discovery. Clear, black and white letter of the law. It's done very often in federal cases, more so to protect government procedures and investigative techniques, but it is done very often more so in federal than it is done in state. Why is it so important here? The Miami Herald, in their response to my motion, put forth some numbers about how many website hits that were related to the article concerning the elevator. And they're like 4,000 here, 4,000 there, 2,000 here on their articles. Just on their articles. And no offense to the Miami Herald, but they're not all this discovery, which will contain salacious materials. They want it all. To bump up the click, ka-ching, which is the money, the revenue that they're driving through the clicks to their site. That's the motivation here for the Herald, to intervene. It's not to protect the public, freedom of the press for the public. They need clicks. That, when we're countering the weight and the influence that this will have on Ms. Clenney's trial down the road, her right to a fair and impartial jury, which I submit to the court by the state already releasing that video, has already elongated the jury selection process by days. This continued drip of information coming through the discovery, which is listed, there's thousands of photos. They did a cell phone download of Ms. Clenney's phone, which is going to contain hundreds of this generation, hundreds, probably thousands of text messages. It's also going to contain content that she would use on her OnlyFans site, which has nothing to do with the events of August 3rd, 2022. I'm sorry, April 3rd, 2022, when Ms. Clenney had to defend herself. It's going to contain, this drop of discovery, I'm submitting a terabyte drive to the state, is going to contain personal text messages with her family, friends, third parties that have nothing to do with this case. And that's going to be subject to Chapter 119, and the media, through Ed Griffith and the state attorney's office, they're going to send links to the media. Here's your public records request link to this video, and it's going to contain.
All right, Jassa asked a question that I think I want to be able to clarify. Artie, what would happen if there was a piece of evidence that's super prejudicial, but it's like a smoking gun, 100% proof of guilt? Would it be suppressed? If so, why? If it would prove the case, you're asking the wrong question. All evidence can be prejudicial. Evidence doesn't have to. Evidence, a literal smoking gun, the gun, used to commit the crime, is prejudicial. It's obviously prejudicial against the defendant. But the question you want to ask is whether or not prejudicial evidence is relevant to the case. If the gun is not relevant, right? Say the fact that the defendant owns lots of guns, that could be prejudicial in that the victim was shot, but it's not relevant to the case because just because you own a lot of guns doesn't make you a murderer. So that's the rule 404. I think it was 404. I can't recall it. That's federal rules of evidence. That the prejudice against it, obviously outweighing the probative value. Correct. So that's probably not going to be an issue here. It's always going to be dependent upon whether or not this prejudicial evidence is relevant and whether or not that the prejudice is outweighed by the probative value. Yeah.
Saying that, we think this video depicts the aggressive nature of Ms. Clenney, offering her own commentary, which, if you turn to the affidavit of Mr. Haas, sorry, Judge, if you can have a moment. Days before, this case needs to be tried in this courtroom with the protections that I know Your Honor will give us to a fair and impartial trial. Jury, and under the rules of judicial administration, a fair and impartial administration of justice. That's why we're here, Judge. The influence that the release of these irrelevant discovery materials will have.
So the defense isn't this is a motion for a protective order, right? Because I guess it sounds like with Florida, you know, Florida has a fairly open transparency laws. So he's worried that the Miami Herald, among other things, are going to get access to the photos, images, text messages that may not necessarily be relevant to the case at hand, but will be salacious enough to, you know, get the Miami Herald some press. The defense attorney saying, well, like, posting all these things about her, pictures of her and potentially sexually explicit stuff is going to prejudice against her, particularly when it comes to jury selection. So that's why he wants the protective order in place to prevent the Miami Herald from disseminating potentially these messages and photos that they receive. Because I don't know if you guys know how OnlyFans work. It's behind a paywall. You don't get the nudes for free.
On her constitutional right to a fair trial. Thank you, Judge.
Thank you. Anything further, Mr. Piega? Anything further?
No, Judge, that's the affidavit is the only
Does
evidence.
this court rely on your motion in reply and the affidavit of Michael Haas? Is that right?
That's correct, Your Honor.
All right. And just for verification, this court's review of the affidavit of Michael Haas, it does not seem to address the geographic location of his research, correct?
That is correct, Judge.
Okay. Unlike the declaration submitted by the Miami Herald, which does address.
Well, that's the thing, Pat's Cats. Thank you for the 499 super chat. That elevator video, I would say, could be prejudicial, and that could be, and I have no doubt in my mind that that's going to be a subject of an evidentiary hearing, and whether or not they're going to suppress the elevator video, and it'll be up to the judge to determine whether or not the prejudicial value, because it's not as if the video depicts the murder, right? It does. It says it has things that lead up to the murder. It has interactions with them, but it's going to be a weighing against the probative value of what that has. Because bear in mind, because think about it this way: they could have been fighting and having an argument, right? You think about this. You know, just because they had an argument, and just because she was the aggressor in the video doesn't mean that she didn't potentially use self-defense in killing her boyfriend. Because again, you're making an assumption there. So that's going to be one of the things that you're going to weigh. It could be very well that as soon as they went back to the apartment, he started going after her. But you don't know that. So that's going to be an issue that's going to be raised in an evidentiary hearing for that specific elevator video. I don't know what the judge is going to decide, but it's not as so it's clear cut that the videos is not going to be suppressed.
The specific Tri-County geographic location of their research.
That is correct, and Mr. Haas attempted to garner that information to verify the local hits associated with those Herald articles, but that information was not accessible to him due to limitations and parameters set on the website that is controlled by the Miami Herald.
Okay, thank you. Any response?
Yes, Judge.
Who would like to go first?
I do not mind it. I believe mine will probably be lengthier, so I don't know.
If he's going to be lengthier, I'll be shorter. Your Honor, thanks for having us today. Scott Ponce on behalf of the Miami Herald. I actually want to talk about what the law requires. And I won't belabor the point because I think what Your Honor just said is very important, pointing out where these views have come from. But the right of access to this material isn't driven by how many clicks there are, how many ka-chings there are, how many drips there are. It's not a numbers-based analysis. There's no bright line that says it's had X amount of views, maybe you restrict it. If you've had less than X, maybe you don't restrict it. Once the information is given, Mr. Prieto said this, and he's absolutely right. Once the information is given or required to be given to the defendant, it becomes a public record. And the way it works, logistically, if that's the right way to say it, is a public records request is made upon the state attorney's office, and the state attorney's office then complies with the public records request, claims exemptions that it deems should be. That's asked, first, closure is necessary to prevent a serious and imminent threat to the administration of justice. And that's the basket in which the defendant has put all of her eggs. And what counsel is arguing is the threat to the administration of justice is that absent closure, the defendant's right to an impartial and fair trial as guaranteed by the Sixth Amendment will be violated. I think it's important to at least say for the record, and it's cited in our papers, and we've cited a couple decisions, we could have cited 10 more, about what it means to have a fair and impartial juror is someone who, even if they've heard about something, will agree to put aside any preconceived notions and agree to base their decision on the evidence that's submitted in court. That's what a fair and impartial juror is. So why did we come forward, Your Honor, with
Basically, what they're saying is that the whatever they're trying to protect, obviously it's going to be in the hands of the district attorney's office, and obviously the district attorney's office is going to be subject to Florida's public records law, and so somebody's going to ask for it, more than likely the Miami Herald, and the defendants has to make sure that it would fall under one of the Florida's exemptions of that records law, where they're saying that disclosure of these records would have an imminent obstruction, I forget how he phrased it, to the administration of justice. The attorney here, I believe he's with the this is the Miami Herald's attorney. I think the state's attorney is going to come up to after him, saying that it's not going to meet that burden.
With the numbers of readership, or number of clicks, as it were, of the articles and video in Miami-Dade, Broward, and Monroe counties. About 10 years ago, just like Mr. Prieto argued, about 10 years ago we subscribed to my client's newspaper, but they don't. And we submitted the numbers we submitted in Ms. Lippman's affidavit to show that even if this were a horse race about how many clicks there are, there's just not that many locally. There's not. And the notion that in a county, and again, the cases, we cite a lot of cases for this and a lot of block quotes in our paper, the notion that you're in a county as large as Miami-Dade County, that you're not going to be able to seat an impartial and fair juror is just ridiculous. It's just not true. And that kind of segues into the second prong of the Lewis test, because again, the Lewis test is the test we're governed by here. The second prong of the Lewis test says, no alternatives are available. I'm sorry, let's throw that there. No alternatives are available other than a change of venue, which would protect the defendant's right to a fair trial. And in the reply the defendant filed, I think it's about 4 lines, 2 sentences, really skipped over it. And this is a very important prong. In every trial Your Honor has ever conducted as a trial judge in criminal court, in every trial Your Honor did when she was an attorney, before she was a judge, we use voir dire to weed out any juror who gives any suggestion that they can't be impartial for whatever reason. They're related to an attorney, they know the defendant. It's a cruise line case and they love to go on cruises. You would do the same thing here, Your Honor, as you would do in every case that's been in this courtroom. You're going to see if anyone in the veneer gives any indication that he or she can't be impartial and base their verdict on the evidence that comes out of the courtroom. So on that basis alone, there's no reason the plaintiff can't meet the Lewis test. And the third prong, Your Honor, is that closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. The defendant, and it's their evidentiary burden, there's been no indication to show the circulation or the views of any of these videos in Miami-Dade County. And indeed, if you look at some of the screenshots, it's a little hard for me to see, I don't have a color copy, but some of the screenshots are like from the Dallas News, from NBC Today Show. I mean, they're not local. They're not local. And so, Your Honor, I won't belabor the point. I know the state wants to speak as well. Just the Lewis test has not been met here, and there's no basis for you to grant the relief that the defendant seeks. If Your Honor doesn't have any more questions, I will.
I do, I have one question, and what is your client's position and your position as to the defense's in the alternative request for partial disclosure?
Well, I don't know what that means. It sounds like being kind of pregnant. I mean, once the defendant gets the materials, they become public records. And the fact that the defendant is showing it to them in a meeting and then taking it back to their office and they're going to talk about it, I think the kind of toothpaste attitude, to use a little bit too many metaphors here, I think that once it's been seen, that's gone. I mean, it's hard for me, having obviously not seen this and not knowing what's there, it's hard for me to talk about what I don't know. I mean, the defendant made the decision, strategic or otherwise, to come in and ask Your Honor for a prophylactic, preemptive relief. Just stop everything. Stop everything.
Is that prophylactic?
They could have waited and said, here are the 3 things that we think for whatever reason should not be gone out, and done it in a much more targeted, specific way, but that's not what they did. You know, we're here on day 2 of these hearings. They came with what they came with. They didn't change their approach, I don't think, in the reply. You know, it was their decision to come and request this kind of blanket preemptive relief, and it's just not appropriate. There's no grounds for it.
Hard, sure.
Thank you, Mr. Ponce.
Thank you, Your Honor.
May it please the court, Philip, when I'm back to the state. Mr. Ponce for the Herald has addressed a lot of it, so my remarks will be significantly reduced. First and foremost, just to address that point, the state made an argument about rightness in its written motion, and I did acknowledge that written in our papers that the defendant's motion was not right, but would inevitably be right. And part of the fundamental problem, and Mr. Ponce just addressed it in the defendant's motion, is that frankly they do not know what they do not know, and they are asking this court to issue a blanket order preventing the state from complying with state law as part of the executive branch. And that's my segue first to the defendant's reply, because the defendant is operating under rules of judicial administration about court documents. As is clear in their pleadings, for example, the legislature is not subject to public records requests because the legislature has not created laws that apply to them. Chapter 119 is what governs the state of Florida and its obligations to comply. And frankly, normally these issues are contested between the state and the Herald, where there are disputes as to what is or is not exempted. The problem here is that we are unusually in agreement where a blanket order is not appropriate, and my job as a prosecutor is to—
Thank you, Pat Scats, for the 199 super chat.
Defendant's motion is not proper for various reasons. One, it's asking the court to sit in excess of the legislature and say Chapter 119 does not apply because we don't like it. And that's not appropriate. Secondly, and I made this argument about equitable relief, and I think it translates also about the quote-unquote drip, drip, drip. This case became newsworthy because of a particularly bloody video that was posted on the news. Instead of remaining silent, the defendant chose to release a public statement on April 8th and released it to local news. A month later, while there was still intrigue, the defendant released another statement to Rolling Stone and Fox News. A month after that, there were more statements. Frankly, it was Mr. Prieto who both informed the press and the state of Ms. Clenney's arrest. He, Mr. Prieto, sent myself and Ms. Hogue an email asking if we had issued an arrest warrant, which at that time was under seal, and frankly, I could have been held in contempt of court had I disclosed it to anyone. And he was the entity that made it known for the state and the press. Again, I have to note, I was in contact with the U.S. Marshals in Hawaii, and they had not called me yet, because Ms. Clenney was allowed to call her mother before, who relayed the message, I imagine, to Mr. Prieto of her arrest, before the state was even aware. It was because of Mr. Prieto and the defendant's conduct that, frankly, there is such scrutiny, and as a public office, we are obligated to answer to the public. As I noted in our papers, the surveillance video that was provided, as much as Mr. Prieto would choose to argue admissibility, I will not go down that rabbit hole.
So if I understand what the state's attorney is trying to say, is that the defense attorney is trying to put in this protective order to try, I guess, to circumvent Florida's public records law. And basically he's saying that it's not appropriate to do that.
Simple fact is that is less than 0.25% of the total discovery in this case. And as Mr. Prieto mentioned about text messages, first it was the victim's phone that we've accessed, not the defendant's phone, and that's noted in the discovery exhibits. But there are 12,220 text messages between them alone, for us to sit over those 9,000 pages on a PDF and go line by line with Mr. Prieto to decide what to disclose to the press is not attainable. First, because frankly it would push the state to have to disclose what it will and will not seek to admit in court. Besides that, one, never made, but two, of particular scrutiny. And that's both criminal and non-criminal, and I can go on for days about other cases, but I won't. The simple fact is the defendant has failed to meet their burden. They're asking the court to, frankly, allow them to control the narrative. And that's without knowing what the discovery is. You know, more than 90% of cases close out to plea resolutions, and God only knows what this case will ultimately resolve as. But the defendant doesn't even know what they're asking the court to seal. And because of that, the court must deny their motion. It is not right. It is not sufficiently narrowly tailored. And frankly, it's asking the court to do something that is not within the court's authority. And for those reasons, we ask that the court deny their motion on the merits.
Thank you. Any final words, Mr. Padilla?
Yeah, Judge, I would like to pick up on counsel for the Herald saying, you know, that the toothpaste is out of the tube. That's exactly the problem that we have here. Once the toothpaste comes out of the tube, we can't get it back in. So what the state is arguing and what the Herald's arguing is saying, hey, just let it all become public record, and then, Mr. Prieto, you and your defense team filter through it and file your objections or motions to seal at that point. At that point, the cat's out of the bag, the toothpaste is out of the tube. We cannot. What will happen is the state will release this under Chapter 119. The media is going to gobble it up in a room full of reporters. Ooh, look what I found. Look at this. And by that time, the defense wouldn't have had an opportunity to have draft a motion, draft some type of protective order, bring it before your honor. That's why we're just trying to preempt the just dump of all these mostly so. And I take issue with the state saying we know exactly what is evidence in this case.
So the defense is basically look, Judge, you know, the state knows, everybody knows. It's all our fucking OnlyFans content, and that's gonna have all the fucking photos and explicit shit on there. And you know, that's basically what he's trying to say without saying. All of her OnlyFans photos are going to be up there for public record. Gonna be like, what was it called? The fappening all over again, but this time it's the government offering it up, not some hacker.
The cell phones, Miss Clenney produced her content on her cell phone. We know that that is out there. Mr. Obumseli's phone probably had some adult content on there as well. Photos, performances. That have absolutely nothing to do with adjudging Miss Clenney innocent of these charges. This is going to turn into a circus of media outlets publishing salacious material that has absolutely nothing to do with guilt or innocence in this case. We can't undo it once it's there. Once it's justice as they should be, it prevents the defense from doing the same thing, which I'm happy to do. Something needs to be put in place, Judge, to guarantee my client's right, but also the orderly administration of justice in this courtroom. Judge, I received, just to talk about the impact of releasing these later, there's no way her self-defense story holds up. She's a psycho that needs to be locked up. This is not the only one, but this is the attention that this garnered. Somebody felt the need to go and communicate with me directly because of this video. And there is no way that the state or the defense can tell you exactly where all these clicks come from. What we know, the volume is extraordinary. Millions, and millions, which in order to protect the fair administration of justice under the rules of judicial administration, when looking at future voir dire, I think a partial protective order is appropriate, Judge. Thank you, Your Honor.
Thank you. Thank you both. Anything further from either side?
Nothing from the state judge.
Not by the defense, Your
All
Honor.
right, thank you. Thank you both for your persuasive arguments. As I said before, this court has had the opportunity to review all motions filed, including the reply that was provided to the court today. I had an opportunity to review the case law that was cited in the intervener's response to the motion, as well as the declarations and the affidavits of both experts. Based on argument presented during this hearing, based on the written pleadings, the legal authority, and the declarations respectfully, the motion for protective order and injunctive relief is denied. This court finds that although this court
Denied.
has discretion pursuant to the rules of judicial administration, this court is bound by legal authority, which is the Lewis test and the three-prong test. Respectfully, I find that the defense has failed to establish by a preponderance of the evidence that all three prongs of the Lewis test has been established. My ruling is without prejudice. At this time, just for verification, the state has not provided initial discovery, correct?
We filed discovery exhibit, Judge, and I've consulted with our public records custodian, and the proffer of that evidence thus subjected to public records requests. As I mentioned, however, and I forgot to note it just because it wasn't on the merits of the defendant's motion, but not everything can.
Y'all know damn well there are degenerates out there like fucking Pornhub or some X-Hamster or some shit who are among those who made the public records request for what was on her phone. Let's not beat around the bush. It ain't just media organizations, y'all. Some degen out there is chomping at the bit to make a compilation sex tape of all of her OnlyFans content.
Contained within discovery is subjected to public records requests. So, for example, a confession of a defendant is not subject to a public records request until the resolution of the case. That's explicit in Chapter 119. That's explicit for the purpose, as such counsel has noted, about protecting the defendant's right to a fair trial, because if we released a confession, theoretically, then the public would be tainted against that witness, or against that defendant. So private material, pornography, sexually explicit material, I imagine my office, because of my personal experience, will have significant objections to, and that's assuming we ever get to the point where the Miami government makes that request, which I doubt, frankly, they would.
Well, maybe that might be the saving grace.
At that point, in succeeding in the Lewis test, and that would be the state that would pursue that, not the defense. And that's true across the board. So we've provided an exhibit. We have proffered that to the defense. We are awaiting whatever digital medium they choose to provide us to give it to them. There is still a significant amount of evidence that we are waiting on, and warrants that are still pending on particular mediums, such as the defendant's cell phone, for example. And so I think we're just in the early stages at this point, Judge.
All right, thank you.
Judge, and not just, I'm providing Mr. Quinnen the defense's check for the 1 terabyte drive so they can get cracking on discovery.
Okay. We already have future sounding and trial dates.
We do,
We'll
Judge.
keep those dates. If there's anything else that needs to be placed on the calendar before then, please feel free to do so, and you can coordinate scheduling with my judicial assistant. Anything further?
Nothing from
either
the state,
side?
Judge.
All right, thank you both. Have a good day.
Thank you.
Thank you.
That's it. Denied. I'm not entirely surprised. I know Florida. I don't know what the Lewis test is. That's what the judge and the state's attorney and the Miami Herald attorney alluded to when it came to protective orders like this, or when it comes to public records access. I'm not surprised. Florida has one of the most open and transparent laws in the country, so they probably had a fairly high burden to meet. If you don't know, I did mention it in the chat, but my understanding, based on when I looked up the docket, her trial date is set for December 8th of this year. So whether or not that sticks, I guess we'll find out. But this is going to end up being, one of those definitely high publicity cases, because You know, when you have an attractive defendant who posted herself on Instagram and OnlyFans, the media is going to eat that shit up. Also because murder, and yeah, murder is always going to gonna get eaten up in the media. So it's got all the hallmarks of a spicy trial that people are going to be following, and of course Florida too. But by the way, guys, who wants a bonus sovereign citizen court hearing? Yay! Wait, do I have something for this? All right. Bonus hearing. Straight out of Telegram. I mean, for fuck's sake, I've joined up with so many sick groups on Telegram. I'm probably going to be on the list. But goddamn, they just love posting their content on there that's never before seen. This is actually out of New Jersey. It's a short but sweet one, but it's out of New Jersey. Funnily enough, here we go. What? No. I'll feed you after. Rat.
Hello. Hereby special appearance.
Mr. Brennan, do you have a camera on your device?
Excuse me, sir?
Do you have a camera on your device?
I do not know, sir.
Yeah, I do not know as he's recording.
I'm not very tech savvy.
What is your address?
52 Bowline Street, Beechwood, New Jersey.
Were you ever at 444 Cable Avenue in Beechwood?
Yes, I was.
All right, what is your date of birth?
1965.
Mr. Brennan, you've been charged with several motor vehicle violations, included among them is a charge of driving while suspended. And I'm going to arraign you on that charge at this time. Do you understand that?
Sir, I'm here by special appearance.
Sir, that's irrelevant to what I just said to you.
No, that's not irrelevant, sir. That's a challenge.
Don't interrupt me. I'm going to arraign you on this charge at this time. Are you refusing to be arraigned? If so, I'll remove you from the meeting.
Sir, what I am doing is challenging the jurisdiction of the court. There's no subject matter jurisdiction, nor is there personal jurisdiction.
I'm not hearing that application at this time, sir. Simply arraigning you at this time. If you refuse to be arraigned, I'll remove you from the...
You know, I just noticed that. You're right. I didn't even notice that when I first saw it. He physically put tape over his laptop camera.
The meeting, you'll be treated as if you did not appear here today.
Sir, I appeared here today. I have appeared here today and through a special appearance, and I'm challenging the jurisdiction of the court. The court.
Though my understanding in many jurisdictions, I don't know if it's the case in New Jersey, in many jurisdictions, they do require you to be on camera. I think for the purposes of identification. So that's kind of odd.
Needs to have jurisdiction before they can, move the matter. Also,
Mr. Brennan, I know what jurisdiction is. I've been doing it a long time, although I appreciate your piece of advice in this matter. Again, I'm telling you the last time, because I'm not going to keep going back and forth, that I'm not hearing any applications or motions regarding the jurisdiction of this court. I am only scheduling you or have scheduled you today for an arraignment on this matter. If you refuse to let me conduct the arraignment, I will remove you from the court session and you'll be treated as if you did not appear here today. Last time, are you going to allow me to conduct this arraignment?
Is there a charging instrument submitted to the court?
Please remove Mr. Brennan from
the
court
course.
session and will be treated as if he did not appear here today.
No, that's not true. That's a lie.
Off the record.
That's great. We're done. Failure to appeared. Get wrecked, nerd. Now I can't remember if this one is also valid. This one's also a good one. I can't recall. Again, from Telegram, as always. These folks, you know, love showcasing, you know, their L's and W's, mostly L's. Actually, all of them are L's.
Acted in your best interests. Have you? Yep.
And I'll put it back out.
What's up with my Zoom guy?
Yep, I'm ready for that now.
All right.
There's one individual with the sign up, so I'm gonna let him back in, and I'm gonna tell him that he has to remove the sign, or I'll put him back out. Next is the Kevin Mackey case, 21 CR 5974. Okay, Karina Newton, you need to remove your sign or you will not be allowed to remain in the Zoom. You'll be put in the waiting room. So remove your sign now or you'll be in the waiting room and you won't be allowed.
I am here in support of Kevin Mackey. Also, Darlene Orvieto, MA corruption exposed. So he's got a lot of his sycophants in his defense. Oh, that's right. I do remember this one. This is involving a reconsideration of a motion that was denied by Kevin Mackey to dismiss the case. Sounds like he was trespassed from a courtroom or someplace for not wearing a mask, and so he refused to leave, and they trespassed him. So that's what the case is about.
Participate.
How about now? Is that better?
Yes.
Yep.
Okay.
All right, and Kamal?
Your Honor, we're here today on Mr. Mackey's motion to reconsider the court's denial of his motion to dismiss. His copy.
Yep. All right, I'm aware. So, Mr. Mackey, it's your request to me to reconsider. I'll hear you.
Very good. So have you read the motion, Your Honor?
I have.
Okay. And you know the facts surrounding the circumstances?
Yes, I obviously do.
Okay.
Right.
So basically what I did was I filed the motion to dismiss. It was denied due to the lack of a supporting affidavit detailing the facts, saying of how my religion conflicts with mask wearing. And what I did was I appended this.
Hold on a second.
Yeah.
Hold on right there. So, that wasn't the reason that the court found on your motions to dismiss, that there was a lack of affidavit regarding how the mask or religious issue settled, but I'll let you go ahead.
Okay. Well, if I'm to quote the denial of the motion, it says, although it appears that the defendant is asserting that he has somehow been discriminated against based on his religious creed, which is a putative fact, he provided no affidavit based on facts known to him, signed by him or another person with personal knowledge of the factual basis of the grounds for this motion. So that's what I appended. That,
go ahead.
So that details the specifics of how the religion conflicts with mask wearing. And I did make my religion known at the time that I tried to enter the courthouse, which is shown by the call for service printout that was attached to my amended motion to dismiss. And this is a violation of my civil rights. It's a violation. It constitutes religious discrimination that the courthouse has committed in violation of Mass General Law, Chapter 272, Section 98.
Okay, so this was actually in Massachusetts. I wonder if I could. All right, I'm going to see if I can find if he videotaped this. Kevin Mackey, Massachusetts. I'm going to let the video play though.
Discrimination in admission to or treatment in place of public accommodation, as well as a violation of the Civil Rights Act of 1964. Since in Ham versus Rock Hill, it says, quote, the legislative history specifically notes that the act would be a defense to criminal trespass, breach of the peace, and other prosecutions, and end quote. And, quote, in effect, the act prohibits the application of state laws in a way that would deprive any person of the rights granted under the act. The Supremacy Clause, Article 6, Clause 2, requires this result, where there's a clear collision between state and federal law, or a conflict between federal law and the application of an otherwise valid state enactment, end quote. The mask mandate acts as an enactment by the state, and the collision exists between it and my detailed religious beliefs. So the law demands that the court dismiss this case with prejudice. I want to add that none of the court officers or police officers attempted any type of reasonable accommodation upon becoming aware of my religious beliefs. I told them that there was a conflict, and they immediately shooed me out. They offered nothing to accommodate.
All right, anything else?
That's all.
All right, Commonwealth?
The Commonwealth would object, Your Honor. There's been no legal reason articulated why the trespass charges in these cases should be.
Your Honor, I object. I can't hear him.
Can you speak up a little?
Of course, sir. The Commonwealth is objecting to Mr. Mackey's motion. There's been no legal reason articulated as to why the trespass charges in these cases should be dismissed. The court's orders and the orders of the court's officers are applied uniformly and are not contingent upon the extremity of one's Messiah complex or the degree of one's religious zealotry, whether that be genuine or fabricated. The trespass charges are not related to his religion at all. He was asked to leave the court. He didn't leave, and then he was trespassed. He still didn't leave, and then he has been charged with trespass. The proper course for these cases is to go to trial. That is the Commonwealth's plan in these cases. The Commonwealth has also offered to resolve these cases with a civil disposition that has been rejected. The Commonwealth would ask for denial of the defendant's motion and to schedule a trial date inconvenient for the court.
All right.
If you guys couldn't hear that muddied mess, basically the prosecutor saying ultimately, like, these are issues that he needs to take up at trial. The issue is the trespass. The defendant is trying to dismiss the case outright on the merits before a trial has happened. This needs to happen. These arguments need to be made at trial and not in a pretrial hearing. I'm basically paraphrasing what the prosecutor's saying here.
So I was the judge on the original motion. I had ample time to review Mr. Mackey's motion to reconsider. And the best that I can figure for Mr. Mackey is the grounds that you are stating might be an affirmative defense, which you can assert at trial, not as a request for dismissal. So your motion is denied. Again, you can bring your affirmative defense to the jury if well-crafted and accepted by the judge at the trial. But
I don't know why this guy's so salty about it. Usually these guys are all about wanting a trial by jury, and he's getting one. Like, he might actually have a better chance of getting an acquittal with a jury trial. I don't know why he's so salty about this.
it's not grounds for dismissal. So the motion is denied.
But Your Honor, there was no probable cause for the arrest since this was known at the time.
Well, hold on a second. I already acted on that motion, right? So then you asked to reconsider, and in reconsidering your motion, I'm finding that that you are not stating grounds for dismissal, that you are stating grounds for an affirmative defense at trial. And if the judge accepts that that's an affirmative defense at that trial, then that will go to the jury to decide. So what's the second? All right. We have I think this matter is going to be moved to a different court for trial, but all of the pretrial matters will remain until that. So are we ready for a trial readiness conference?
We've had a trial readiness conference already, Your Honor, so it might be best to select a trial date. Although I can't speak to the trial schedules of the outlying courts, so I don't know entirely where the trial will be.
And I don't know where it will be either. All I know is that I think it has not been chosen yet, because I didn't realize there was a trial readiness already. Yeah. Hold on.
Nothing's happening.
So,
On the 20th,
okay.
We're setting a trial date.
I do note that on the docket.
Okay. All right. Well,
July 29th.
would have been nice if the trial readiness form was filled out by the judge. But okay. All right. So I think we're going to have to notify you, Mr. Mackey. I think we should, but we should put it on some date in the future for, something like I would prefer that it be another trial readiness so that we can gather and file any motions if need be. December 2nd, Madam Clerk? That's December 2nd at 11 o'clock in the morning.
December 2nd. That'll be fun.
Courthouse this is going to be transferred to, but I will tell you that it can only be transferred within Hampden County. Holyoke, did I say Holyoke?
All right, I think that was actually it. I thought he had something spicy to say actually afterwards, but no, he didn't. All right, I'm gonna end it there because I actually have work in the morning. So what? What? Winston. Come here. No. All right. You guys have fun? No. All right. I gotta actually go feed them. They haven't had their meals yet. I haven't had food yet either, right, kitty? Yeah, exactly. All right. I'll see you guys next time. Have a good one. Go check out Law Talk with Mike. I think he's live right now. Meow. Or Irish Demon. And you guys have fun. Take care. Goodbye. All right. Bye-bye, guys. Later.